If your spouse turned against you tomorrow, how much of your money would still be yours next week? Stay with me, because the moment divorce meets business betrayal, the rules change fast. And if you don't know them, your wealth can disappear before the ink dries. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. And for 34 years, I've helped clients protect what they've built. And for nearly 30 of those, I've set up Cook Islands Trusts, more than any firm in the world. And in this video, I'll show you step by step how smart people keep control when emotions run hot and papers get served. Before we dive in, if you want proven legal strategies to shield what you own, please stop right now and check to make sure that you're subscribed and hit the bell. It really helps out a lot, and you'll learn the playbook the wealthy use without the hype. And if you're already feeling the pressure right now, feel free to visit assetprotectionplanners.com. You get a whole lot of free information there so you can get calm and get a plan. Let's start with the shock. One day, you're sharing a bank account. The next, you're getting served. And your spouse's attorney just asked the court for a financial restraining order, freezing moves, freezing transfers, freezing life. Here's the first big truth. The clock starts ticking the moment divorce papers are served, or even when it's clearly imminent. After that, most asset moves are either blocked or can be unwound. Cliffhanger. In a few minutes, I'll show you the one structure that, when set up before the storm, is designed to hold up even if a judge pounds the gavel. Now, we'll get there, but first, we'll need the ground rules. First of all, plain English definitions. Let's define our terms. Marital versus separate property. Now, marital is what you acquire during the marriage. Separate is what you owned before marriage or what you received as a gift or inheritance. Mix them carelessly, and separate can become marital. Next, commingling. That's when you mix separate money with joint accounts or use it to pay common expenses, such as your mortgage payment. That way you can turn mine into ours fast. Financial restraining orders. These are court orders that stop you from moving your money once a divorce is filed. Ignore these and judges can reverse transfers, sanction you, or worse. Here's a quick stat. In the U.S., roughly 40 to 50% of first marriages end in divorce. The rate is higher for second marriages. For business owners, divorces often include fights over company equity, debt guarantees, and control. Translation: plan early. Now, most people think divorce only splits a house and a checking account. Wealthy families face 4 bigger threats. Number 1, equity drain. Houses, rentals, and vacation properties are loaded with equity. That equity is the jackpot. Number 2, business leverage. If your spouse has a claim to your company or its cash flow, your income stream is the battlefield. Number 3, personal guarantees. If you guaranteed business debts, divorce can push lenders to tighten the screws. Number 4, weaponized discovery. Subpoenas pull bank statements, tax returns, emails, everything. Lawyers comb for weak spots. Any sloppy transfers or late night wire moves, they glow in the dark. Real composite case. A Florida contractor came to us after the "we need a break" talk. He had rentals, a 7-figure business, and a spouse now guided by a very aggressive attorney. He wanted to refinance the rentals real quick. Problem: a restraining order was already in play. Moves after that were likely to be reversed. And we could still help, but the options shrank overnight. Cliffhanger. In a moment, I'll show you how we make equity boring so hungry lawyers stop chasing it. Now, here's a rule that almost nobody tells you. Timing beats tactics. If you move assets after divorce papers are filed, or when it's obvious they're coming, courts can call it a fraudulent transfer and pull it back. So that's why we plan early. Here's what early looks like. First, you've set up protective structures while waters are calm. Your reasons are legitimate: privacy, estate planning, business risk, lawsuit protection. You keep records. You act like a grown-up and not a cartoon villain. Now here's what late looks like. Your texts say, she's filing now, move the money, or wire funds at 2:13 a.m. to a cousin, or you suddenly sell your Porsche for $500 to your best friend. The problem? Your spouse's attorney will sue those people who help you. Judges see that movie every day. Don't be in it. Okay, now what does work when we set it up on time? The answer, Offshore Asset Protection Trust paired with a foreign LLC. Yes, this is where the Cook Islands comes in. So stay with me and I'll open the toolbox. Okay, here's the calm water setup. Cook Islands Trust plus Cook Islands LLC combination. Now, for nearly 30 years, our team has built a very specific structure that has protected clients again and again. Here's a simple version in plain English. First, you create a Cook Islands Trust, and that's the legal fortress. Inside of it, we place a Cook Islands LLC. Now that's the toolbox. Now when seas are calm, you're the manager of the LLC. So in other words, you have something inside of this fortress called the LLC that you are the manager of while things are calm. That's the reason why we put the LLC inside. So you can bank, invest, and live normally. Now, when a legal storm hits, we change the manager of that LLC. So at least you have divorce, lawsuit, demands. Our licensed bonded trustee company and law firm in the Cook Islands, the most regulated trust jurisdiction in the world, steps in to protect you. They follow the terms of the trust, protect your assets, and they do this only when needed. Okay, why this matters in divorce. U.S. courts, or courts wherever you live if you're not a U.S. person, can order you to bring your assets back, but a Cook Islands trustee is bound by Cook Islands law, not by a judge in, say, California. The trustee cannot legally move money just because an American lawyer yells loudly. The mismatch of legal power, that's the whole point. Important. Now, this is not about hiding. This is about jurisdiction and legal duty. Done early and properly, it's lawful and very effective. And we do this for clients all over the world. Cliffhanger. In a couple minutes, I'll show you how we protect U.S. real estate equity, even though you can't teleport a house to an island. Okay, let's talk about business betrayal, what ownership and income are on the line. Okay, next, business betrayal, when ownership and income are on the line. Now, divorce doesn't only split property. It can threaten control of your business. Let's fix that. Holdco versus opco. That's the core structure. In other words, we separate the operating company, that's the risk, payroll, customers, from a holding company, intellectual property, brand, critical equipment. Holdco, the holding company, licenses assets back to the operating company for a fee. So if a divorce hits the business, Holdco's value can be insulated. And then we record UCC-1 liens against both companies to strip the value. Equity in voting. Where state law allows, we split voting control from economic interest. The spouse may get a share of value, but not the steering wheel. Next is income planning. We aim for a reasonable salary plus distribution that fix tax law and don't look manipulative. Judges punish games. We design for fairness and defense. Okay, here's a composite case study for you. The clinic director, a medical entrepreneur, owned a chain with $6 million in revenue. So we set up Holdco, Opco years before. In other words, one company held the assets, the other company operated the business that had all the risk. So they're separated, the company with the assets versus the company that has the liability with the customers. When divorce hit, there was an argument over value, but not over control. The practice stayed open, staff kept jobs, and settlement was paid from cash flow, not a fire sale. Here's a cliffhanger. In a moment, I'll show you a simple test that tells you if your business is divorce fragile in under 60 seconds. Okay, real estate, making equity boring to attack. You can't offshore a duplex, but you can make the equity hard to grab. So here's how we do it. Legally, number one, title privacy. Often we hold title in a land trust for privacy. So the beneficiary of that land trust is an LLC in your plan. Next is equity stripping. So here's how we do it legally. Number one, title privacy. We often hold title, for example here, in land trusts for privacy. The beneficiary of each land trust is an LLC, except for your personal residence. Next is equity stripping. We record proper mortgages. These are line of credit mortgages, so there's no money changing hands initially, against your properties payable to your Cook Islands LLC that's inside your trust. Number 3, the third party option. If needed, we get extra muscle. Independent lenders can purchase those mortgages and funds and the proceeds go into your offshore asset protection trust. That way it's beyond the reach of the local courts. So on paper, your properties have very little reachable equity. And it actually doesn't have equity because it's been all stripped away and put into a place that your opponent can't touch it. So plaintiffs and opposing divorce counsel see a dry well, so they look elsewhere to settle. Here's a composite case study. The 8-door landlord, a client with 8 rentals worried about a scorched earth divorce. Now before filing, we set up the proper liens and aligned ownership. Now, when the divorce arrived, there was still a fair division discussion, but the easy jackpot equity was off the table. The case settled without selling a single door. Here's a key reminder: do this before the divorce is served or obvious. Timing, timing, timing. That's the big secret here. Okay, so here's the 60-second business fragility test. So grab a pen or computer keyboard and answer yes or no to each one of these. First, if your bank locked your line of credit, if you have one, if they locked it tomorrow, does your company stall? Number 2, is your intellectual property owned by the same entity that gets sued? In other words, your trademarks, your copyrights, your patents. Are they owned by the same entity that runs your business? That should be separated. You need to have a holding company that has very, very little interaction with the public, so very unlikely it's going to get sued, and a separate operating company. The holding company should own your stuff, the things of value, the intellectual property, the equipment, separately from your operating company. Okay, next, could a stranger with enough money learn your top 5 customers from public records? Next, do you have personal guarantees on big leases or loans? Could your spouse's lawyer subpoena one bookkeeping login and see everything? So 3 or more yes answers, fragile. The fix is structure, access control, and clean documentation. We do this all day. Okay, next up, let's talk about prenups, postnups, and reality. Okay, prenup is a contract you sign before marriage to set the rules about property and support. Postnup, same idea, but after you've been married. Harder to enforce, must be very fair and very transparent. Now, both can help, but neither is a shield against lawsuits or business risks themselves. And I'll tell you what, we see them penetrated left or right. If you have an aggressive attorney, we've seen pretty much any prenup or postnup that can be penetrated, or enough doubt is placed in the judge's mind that they can get through it. That's why many clients use prenups plus a Cook Islands Trust structure. The prenup sets expectations, and the trust actually provides the protection. It holds the line when court pressure rises. Here's a practical tip. Don't mix your separate property with marital accounts. Keep clean records, clean titles, and clean habits. Cliffhanger. Next, the 5 mistakes that blow up otherwise good plans. Number 3 surprises just about everybody. Okay, here are the 5 mistakes that blow up good plans. Okay, number 1, last minute panic moves. Write this down if you want. If papers are filed or obviously coming, stop. Call counsel immediately. Number 2, text message confessions. I'm hiding it, or she'll never find it. Congratulations, you just wrote opposing counsel's favorite slide. Number 3, beneficiary whiplash. Changing trust beneficiaries mid-fight looks like gamesmanship. Stability is what wins. Number 4, sloppy bookkeeping. If your books look like a spaghetti bowl, the court assumes you're hiding meatballs. Clean books equals credibility. Number 5, DIY legal engineering. Now, YouTube's great for recipes. With asset protection, one wrong bolt and the engine throws a rod. So make sure you get professional guidance. Like I say, we've set up more of these asset protection structures than any firm in the world, and so we can guide you in the right direction if you're serious and not curious. So what to do instead? First, build early. Document why you did it. Do this early, document why. Behave like a fiduciary for your future self. Okay, so let's talk about questions. What's the difference between doing this offshore and doing it domestically? Why jurisdiction matters. So people ask, why not just set up a domestic asset protection trust in Nevada, Delaware, Wyoming, South Dakota, Alaska, wherever? Okay, short answer, U.S. judges can order U.S. trustees. Enough said. Domestic trusts improve posture, but when emotions run hot and pressure ramps, local judges have local reach, and that's why we've seen these domestic trust penetrate left and right. With the Cook Islands Trust, on the other hand, the trustee obeys Cook Islands law. U.S. judgments aren't recognized there for these purposes. That's the backbone. So pair it with a Cook Islands LLC while you manage in calm times, and this trustee steps in to protect you only when under legal fire. So that balance, control when safe, protection when attacked, is why the structure has become the gold standard for serious planners. And yes, like I said, our firm has set up more Cook Islands Trust than any firm in the world. So that's our lane. Okay, so what if you're already in the middle of it? Maybe you're already separated. Maybe filing is days away. Two things. First of all, don't lie. Don't hide. Courts punish deception. Next, don't triage, lock down operations, restrict user access to finances, stop voluntary transfers without counsel. We build a forward-looking plan so we can still help, especially with business continuity, income planning, and settlement strategy. Sometimes there are still lawful moves to preserve value, even if we can't reposition everything. So here's the human truth. Judges like stability, payroll, continuity, and reasonableness. So show you're protecting employees and creditors and not just playing games. Okay, here's your action plan, the divorce proofing checklist. So write this down. First of all, banking. Separate operating, tax, and reserve accounts. Controlled access. Dual approvals for wires. Next, equity map. Holdco owns your intellectual property. Opco runs operations. Rental properties sit in discrete separate LLCs. Okay, trust an LLC. Establish a Cook Islands Trust with a Cook Islands LLC inside of it. That's what we do. You manage the LLC when calm. Our licensed bonded trustee company law firm steps in under pressure only then, okay? Real estate lien. Properly documented mortgages and lines of credit, which we can set up for you, to your Cook Islands LLC initially, and then optionally a third-party lender purchases those liens if needed and puts the proceeds in your trust. So it's protected. Next, records. Clean books, clean titles, and clear reasons for every move. Okay, insurance. Keep it. Asset protection complements insurance, but it doesn't replace it. Communication rules. No hot-headed texts. Assume a judge will read every single message out loud. Here's a team thing. Lawyer for family law, separate lawyer for asset protection. Don't mix the two. You wouldn't go to a foot doctor for brain surgery. Don't go to a family lawyer for asset protection. Go to a specialist. Like I say, our law firm is the specialist in that area. A CPA who thinks in structures, not just tax season. So if you need help now, feel free to go ahead and visit us at assetprotectionplanners.com. Get a whole lot of free information there. So get your options and keep your calm. Okay, final story. A client, we'll call him Daniel, owned a multi-state logistics company and 6 rentals. He called after a painful conversation. His spouse, she had retained counsel, a discovery request for coming. But Daniel had done one thing right years earlier. He built a plan. He called us and built a plan. The company's brand and contract sat in Holdco. The trucks and payroll ran through Opco. Real estate had liens to his Cook Islands LLC. The trust and LLC were established long before marital trouble. So what happened? The divorce was still hard. There were tears. There were negotiations. But there was not a fire sale. Nope. There was no everything must go. Staff kept jobs. The company kept running. The settlement was for a number, not a bonfire. So that's the difference between panic and a plan. Now, divorce mixed with business betrayal is emotional. I've seen this with so many clients, but emotion is a poor engineer. Structure is how you win, quietly, legally, and for the long run. I'm Kevin, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. My team and I have helped clients protect their wealth for 34 years, and we built Cook Islands Trust for nearly 30 of them. So if you want a plan used by serious people, the one where you manage in calm times, and our licensed bonded trustee company law firm steps in only when needed, reach us at assetprotectionplanners.com. And if today helped, subscribe. We teach the real playbook, the one built when life gets loud. So stay safe, stay smart, and I'll see you in the next video.